Article 243ZJ of the Indian Constitution deals with the composition and tenure of the members of the board and office bearers of cooperative societies. The article outlines several important provisions related to the structure and functioning of cooperative society boards. 1. Number of directors on the board. The number of directors on the board of a cooperative society is determined by the state legislature through laws. Maximum limit: the total number of directors cannot exceed 21. Reservation: there is a mandatory reservation of 1 seat for scheduled castes, SC, or scheduled tribes, ST. 2 seats for women, applicable to societies that consist of individual members and include members from these categories. 2. Term of office for elected members and office bearers. The term of office for elected members and office bearers is 5 years from the date of election. The tenure of the office bearers, example President, Secretary, is conterminous with the board's term, meaning their term ends when the board's term ends. Filling casual vacancies. If a vacancy arises on the board before the halfway point of its original term, it may be filled by nomination from the same category or class of members to which the vacancy belonged. 3. Co-option of members with expertise. The state legislature may, by law, allow for the co-option of members with expertise in fields like banking, management, finance, or any other specialization relevant to the activities of the cooperative society. Limit on co-opted members. The number of co-opted members cannot exceed 2, and they are in addition to the 21 directors mentioned earlier. These co-opted members do not have the right to vote in any election, nor can they be elected as office bearers of the board. Functional directors. The functional directors of a cooperative society, meaning those holding key executive roles, will also be members of the board. However, they are excluded when counting the total number of directors, that is, they are not included in the 21-member limit. Key takeaways. The state legislature has the authority to regulate the number of directors, and there is a cap of 21 directors. Reservation is provided for SC, ST, and women to ensure inclusive representation. Co-option of experts is allowed but with certain limitations on their rights and powers. The term for elected board members and office bearers is 5 years, with specific rules for filling vacancies. The Constitution of India. Part 9b. The Cooperative Societies. Article 243ZJ. Number and term of members of board and its office bearers. 1. The board shall consist of such number of directors as may be provided by the legislature of a state, by law, provided that the maximum number of directors of a cooperative society shall not exceed 21. Provided further that the legislature of a state shall, by law, provide for the reservation of 1 seat for the scheduled castes or the scheduled tribes and 2 seats for women on board of every cooperative society consisting of individuals as members and having members from such class of category of persons. 2. The term of office of elected members of the board and its office bearers shall be 5 years from the date of election, and the term of office bearers shall be conterminous with the term of the board. Provided that the board may fill a casual vacancy on the board by nomination out of the same class of members in respect of which the casual vacancy has arisen, if the term of office of the board is less than half of its original term. 3. The legislature of a state shall, by law, make provisions for co-option of persons to be members of the board having experience in the field of banking, management, finance, or specialization in any other field relating to the objects and activities undertaken by the cooperative society, as members of the board of such society. Provided that the number of such co-opted members shall not exceed 2 in addition to 21 directors specified in the first proviso to clause 1. Provided further that such co-opted members shall not have the right to vote in any election of the cooperative society in their capacity as such member or to be eligible to be elected as office bearers of the board. Provided also that the functional directors of a cooperative society shall also be the members of the board and such members shall be excluded for the purpose of counting the total number of directors specified in the first proviso to clause 1.